A leave to amend was made and to add counts 8 and 9. And I don't know if there's a question about the standard of review with respect to the court's denial of the motion for leave to amend to add these counts or not. We've addressed it in the briefs. We say it is de novo. It's equivalent to summary judgment being granted against Touchstone on counts 8 and 9, and that certainly would have been a de novo review. Counsel talks about misapplying law, but that's also can be an abuse of discretion. So we don't think there's any question about the standard of review. The court said, we're not going to let you amend because it's futile to let you amend, and that is a de novo review. The court didn't have any discussion of the minute entry, didn't have any oral argument, simply said these new counts would not survive the authorities mentioned by the escrow agent in its motion. Count 8 was for negligence in the preparation of the escrow instructions in the deed. Now, the deed says that the Touchstone takes it subject to all encumbrances of record. That was not the parties' agreement. The agreement was it was to be free and clear. All parties, buyer, seller, escrow agent, knew that. There's testimony in the record on the depositions that, yes, the escrow agent understood that. And
how often does a deed just declare that it's free and clear?
When there's attorneys involved. But
in a case like this where there aren't attorneys involved, the parties didn't even do a real contract here.
Only the escrow instructions.
The standard deed that you would expect from a title company.
No, I mean, maybe some title companies say this is the one we're going to use. I can't say one way or another on that, but it is contrary to the parties' agreement because, and if a buyer really thought about it, he would never accept a deed that said subject to all encumbrances of record because that's not the usual intention when a buyer is purchasing property. He expects it to be free and clear. Now, unless there's a direct assumption and agreed upon assumption of liens. But
how often, though, have you seen a property that isn't subject to some encumbrance? There's always an easement, power line easement. There's something that's an encumbrance. And so the standard language of the deed is subject to certain encumbrances that may not bother the buyer.
Well, I think there often are easements and stuff, but those are easements, and we submit those aren't the encumbrances that we're talking about here. And
not the one you're concerned with
right.
today, but from the standpoint of a title company, aren't encumbrances by the time you get to the deed level, and everything else is dealt with usually beforehand in terms of title search and title insurance and vehicles like that. I mean, clearly what happened here is not what the parties intended, but
correct.
The question is whether the documentation itself falls short.
Well, there is nothing in the escrow instructions about the deed. And the escrow agent didn't get approval for the deed, just use a deed, it's not signed by the buyer. And unfortunately, they picked one that says subject to all encumbrances of record, in which.
But if your whole contract is escrow instructions,
there's no separate written agreement. That is correct.
Which is unusual. But if your whole contract is going to be the escrow instructions, wouldn't you draw those up pretty carefully?
Yes.
Then you'd have something to argue about. But the escrow instructions didn't say thou shalt use a deed that declares itself free and clear.
Right. The escrow instructions don't say anything about the deed. The escrow instructions were prepared by the escrow agent, and it doesn't mention the deed whatsoever. And so we submit it should be consistent with the parties' intent, an intent that they were well aware of, and it's not. And what it did was extinguish any claim against the seller.
We may be bumping up against, I hate to say it, bumping against some economic loss rule jurisprudence then. I mean, if this is a contractual arrangement and the party is going to claim that one party negligently drafted the contract, how viable a claim is that as a matter of law?
Well, I think it is a viable claim. I mean, they were aware of the agreement and they took it upon themselves to prepare the escrow instructions, knowing that this was the only written agreement between the parties. And that's That's preparation of the escrow instruction. Preparation of the deed, though,
But then to whom do they owe the duty when they're preparing those instructions? Do they owe a duty to the buyer to make sure that the escrow instructions are as buyer favorable as possible?
no. I think they owe a duty to both parties that if they're aware of the agreement, that the documents have to be consistent with that agreement. And they're not. The deed is not. And the deed cut off the right to proceed against the seller, so there is real damage here. Now, the escrow instructions don't mention the deed, so the court's ruling on contract and negligence that the contract wasn't breached, the escrow instructions, and the escrow agent followed the escrow instructions don't preclude this claim because the deed is not mentioned in the escrow instructions. And that's the essence of the court's holding, is that you're out of luck because I've already ruled they didn't breach the contract and they weren't negligent. But in point of fact, we're in following the escrow instructions, and we're saying, well, if that's your ruling, court, then they prepared them wrong because the escrow agent knew what the deal was and prepared them wrong. So,
And your client signed it.
I'm sorry, what?
And your client signed it.
Yeah, because the escrow instructions say 0 encumbrances of record. They appear to indicate no encumbrances of record. I mean,
The escrow instructions say that?
yes, that's in the brief.
It's clear that the understanding was that there was no deed of trust, and the parties were well aware that there was a concern that there might be a deed of trust applicable to the property in question, right?
Right, there clearly was. The foreclosure, though, happened at about this time, and that's why when the email came, it said, after the foreclosure, here's what's left.
Right, and the escrow instructions say, once you've made sure that there's no deed of trust, you may release the funds, right?
No,
Okay,
the escrow instructions say 0 encumbrances of record. They don't specifically refer to any deed of trust or any encumbrance.
what way were they negligently prepared?
The escrow instructions?
No.
Because this court has held, not this court, the trial court held that it doesn't mean they have to clear liens, and that's contrary to the parties' agreement. Matter of fact, that was the concern before they even talked to the escrow agent about the property, was that this Northern had a huge lien on the property, a lot more than the value of the property, and it couldn't be purchased unless that had been satisfied. But again, the ruling by the trial court that the escrow agent followed the contract and followed the escrow instructions doesn't preclude a claim for sending a deed that's not consistent with the parties' agreement, because the contract doesn't mention the deed. Defendants say that this is a ghost agreement, and maybe they can explain more what they mean by that, but in point of fact, all parties knew the agreement. There's absolutely no dispute of that. It had to be free and clear of liens, and in point of fact, this is not an unusual agreement. This is how property normally is purchased. If you're going to assume a lien, you have to know what it is. I mean, if it's more than the value of the property, obviously there's no deal. But this is a usual type of agreement, and all parties were aware of it, so there's no ghost agreement here. This one was very much aware, the escrow agent was very much aware of it. So the deed was prepared contrary to the escrow instructions, and the escrow agent was negligent in doing that. That was part of count 8. The other was the escrow instructions themselves. We say they were negligent in preparing them because the trial court held that they don't mean you have to clear encumbrances of record. But that's what they went about doing. There were 2 other potential liens on the property. They went and actually got indemnity agreements on those, I believe. But they knew what they had to do. The escrow agent, Becky Landon, had been advised by another employee of the escrow agent that don't have to worry about the Northern lien. It's been taken care of by the foreclosure. But it hadn't been. And it was negligent to assume that, in fact, it was. And again, the fact that the court held that they followed the escrow instructions doesn't preclude a claim for negligent preparation of those escrow instructions within its ruling. Now, the negligent misrepresentation was count 9. This was part of the same motion to amend. And again, that's what the escrow agent said, is here's what's left after the foreclosure. And the property is free and clear. Now, this is not a preliminary title report. The only preliminary title report in existence at the time, which gets certain protection under Arizona law, was the one that said there is a lien out there. So Touchstone was not relying on any preliminary title report. This is a statement by the escrow agent, here's what you have left after the foreclosure. And there's a dispute as to whether or not Touchstone got any other title commitments. But our claim is not based under that. It's based upon their statement to us that the property, here's what's left after the foreclosure, the property is free and clear of liens. And again, the fact that they may have followed the contract or weren't negligent in carrying out the escrow instructions doesn't preclude this type of count. And it's not covered by the judge's prior ruling, granting summary judgment on counts, the negligent and contract counts. Now, in the supplemental brief, title management says that, well, what they're really saying is they're targeting, I'm not sure what that means, the title commitment. And they point to some two paragraphs in the second amended complaint that says, see, this is what we're talking about. But if you look at them, it mentions title insurance policy. That's not what we were targeting in our second amended complaint. Count 9 was, I think, very clear that you told us it was free and clear, and it wasn't. You said, here's what's left after the foreclosure, and that's not true. It was encumbered. Now, when the court said that you can't bring counts 8 and 9, there was absolutely no analysis. I think it was a one-line ruling, and as to how the elements of 8 and 9 were already decided when the court decided the contract and negligence counts. And quite frankly, title management didn't discuss the misrepresentation below when it filed its response to the motion for leave to amend. So we submit that that was wrongly decided. We should have been allowed leave to bring those provisions. Well, I don't have much time here. So we submit the court erred when it granted summary judgment on the contract and negligence counts. We've always said, Judge, it either says 0 encumbrances, meaning there aren't any, or it's ambiguous. And if it's ambiguous, you look to the party's intent. And everybody knew what it was supposed to be, so we should win. And if it's no provision at all about prior encumbrances, then the escrow agent can't turn a blind eye to anything. It has to know what the party's intent was and act in accordance or get instructions. It didn't do that. It thought it was complying, but it wasn't, because it was under the mistaken assumption that that lien wasn't there. But it can't ignore what the party's agreement was, and in fact, that's essentially what it did. The negligence count, the court said, well, you have no right to rely on the title examiner employed by the escrow agent when they obtain a policy of entitle insurance. But in order to close escrow, the escrow agent needs to know what to do. And that's when another member of the same company tells it, here's what you have to do. You have to clear these liens and whatever else you have to do. And that's what it did. And that's when the escrow agent went ahead and went about clearing the other two potential liens on the property, but felt that the one to Northern had been satisfied because the co-employee said that, and so they didn't do that. And it was negligent to do that. There was still a lien on the property, and it had not been extinguished by the trustee's sale. Now, of course, if the court reverses on 3 or 4, we submit all the issues go back down, because all other issues depended upon the court's rulings on counts 3 and 4, the negligence and contract counts. Covenant of good faith and fair dealing is normally a fact question. They didn't even submit a separate statement of facts. They just made a short motion for summary judgment. The court granted it, but it's clear that you can breach the covenant of good faith and fair dealing without breaching an express provision of the contract. So the court's ruling that there was no breach of that written contract doesn't preclude a count based on the breach of the covenant of good faith and fair dealing. And what was the reasonable expectation of Touchstone? To get property free and clear. Did that happen? No, it did not. Was the escrow agent aware of that expectation? Absolutely. The breach of fiduciary duty was either 6 or 7, one or the other. That would second motion for summary judgment was brought on. And that, again, an escrow agent can be liable even if it follows the escrow instructions. Therefore, the court's ruling that it had followed the escrow instruction doesn't preclude a count for the breach of fiduciary duty. I'm going to save a few minutes here, but And I think that's on attorney's fees. The attorney's fees provision of title management, actually, I'll just save that time and I'll respond depending on what the comments are. Thank you.
Thank you, counsel. Counsel?
Good morning, and may it please the court. I'm Joshua Carden here for Title Management and Western Surety. As I listen to the argument, as I've been rereading the briefs in this case, the first thing that always comes to mind is thank goodness for title insurance and thank goodness for lawyers in cases like this. The parties' agreement, Mr. Ensign said those words several times, and the big difficulty with this case is, as far as the law is concerned, when we're talking about a transfer of property, statute of frauds says that agreement needs to be in writing. There was no writing between the parties in this case other than these escrow instructions. That's not something that can be hung around the neck of title management. It just can't be. That's not how the law works. In terms of the duties that title management had, I think the court's done a great job of making clear that there are different duties for title insurance companies and escrow agents. Escrow agents have a duty. They obviously have a duty to the parties in any transaction, and that is to act with scrupulous honesty and diligence in accordance with the instructions that they're given. That is the holding in the Berkins v. Ticor Company, and I believe that decision really controls the outcome of this case. And that decision says if you've acted in accordance with the escrow instructions, that's all you have to do. Unless there are other documents that you have to follow that are submitted in connection with escrow, then yes, you have to include those as well. But we're not going to expand to go beyond and reach the subjective intentions unexpressed in the writings that are part of the escrow. And that's essentially what Mr. Ensign's clients are asked the trial court to do, and the trial court properly said, no, I'm not going to do that. I'm not going to expand the duties of an escrow agent to be legal counsel or business advisor and basically put the escrow agent in charge of the transaction. That's essentially what the appellant would have this court do, is to say, no, the escrow agent's job was to make sure that what the parties wanted but didn't write down actually took place.
Is it the lack of a writing that's critical?
In this case, I think it's absolutely critical.
Critical factually?
Critical factually and critical legally, because, I mean, Mr. Ensign agreed just a few minutes ago that there is no separate written agreement. The escrow instructions are it. And so at that point, every time he has said the words the parties' agreement, what he's talking about is this discussion between Touchstone and the DYRCZ to have this be a free and clear deal. That's the agreement. When he says the parties' agreement, that's what he's talking about. When I say the parties' agreement, I'm saying there's only one. It's not a combined agreement. It's got an integration clause. Everything that the parties want is contained in these escrow's instructions. And so when the deed gets prepared based on these escrow instructions, there's no specter of fraud. There's no sign from the deed matched to the escrow instructions that the deed was somehow prepared separately than the way the escrow instructions read, and the trial court dealt with all of that. So then we're left with these negligence claims and contract claims, and for a negligence claim to have any teeth at all, it's got to be grounded in some sort of duty. And the duty that is being identified in this case by the appellant is to say that not only should you have had to follow the escrow instructions, but you should have also given effect to this subjective agreement that wasn't written down. That's what I mean by the ghost agreement. It's a ghost because there's no record of its existence in writing, and that's what you got to have.
I'm just trying to understand how far you say the consequences of the lack of writing go. If they had a clear contract, not in writing, and the title company had full understanding of that oral agreement, how does that affect the title company's responsibilities?
I think that takes us right back to Berkins, Your Honor, because we have a subjective intention not manifested by anything else other than oral statements that in theory could be changed on a daily basis all the way up to the time of the closing. And that's the danger. That's why we do statute of frauds. That's why we say you must have a writing. Because without that, we're left with the ability of the parties to change those subjective. I mean, that's the word from Perkins. It's a subjective intent that the court is saying, no, we're not going to throw the gates open wide and say, all you escrow agents, not only do you have to account for the escrow instructions, not only do you have to account for any other documents deposited with you as escrow agent, now you have to give effect to what the individual parties subjectively meant. And frankly, I think that rule is sound, because how in the world could an escrow agent act fairly and still give subjective intent, effect to the subjective intention of the parties? Because those subjective intentions might not match. The only thing that can match is when we have written escrow agreements. The written escrow agreement does not say free and clear. It does not say it will be transferred free and clear of all liens. The deed is a standard deed. Subject to all encumbrance of records is relatively, that's not unusual language. So when we close the deal, that's what happens. And that brings me back to, thank goodness for title insurance. That's why you have title insurance. So if there is a mistake, there is some recovery. You don't hang the consequences of there, in fact, being another encumbrance around the neck of the escrow agent, who, in this case, there's nothing to suggest that they acted inappropriately with the duties that they were entrusted, the duties that the court has outlined, the duties that statutes outline. You handle the escrow process fairly, and if you know of fraud, you better disclose it, but that is the perimeter of the duties on an escrow agent in this case.
But here, isn't it arguable that the escrow agent took on a little bit of an extra role by communicating about an investigation, the steps of the investigation, and offering some assurance that in fact the property was free and clear when that was mistaken? I mean, that's not something escrow officers ordinarily do, but they seem to be emailing back and forth and assuming a little bit of a different role than we're used to seeing.
And that's true, and that's, to be honest, I think that question is dealt with by Centennial. That was the, as the supplemental briefing was analyzed, is to say, again, we're separating out here, is this them acting as escrow agent or acting as title insurer? And we have to keep those duties separate. But to say, we've represented that it's this way, and oh, by the way, come to find out that it's not, that is the whole point of the statute that was analyzed in Centennial, is to say no negligent misrepresentation. We've provided the cause of action for this.
But Centennial dealt with a title commitment. These communications went beyond that even.
These communications go to what the title commitment showed or didn't show, and that's where I think it's like Centennial.
Well, I mean, how often is it that a purchaser of property gets personal emails from the title company saying, okay, this was really confusing, but we've looked at it and here's our view? That's a little bit different than the form document that the statute at issue in Centennial was addressing.
It is slightly, Your Honor. However, I think where the difficulty lies in, again, is, are they acting as escrow agent? If so, is that part of their duty? In other words, is that a duty? Can the subjective response by the parties to the escrow instructions trigger or create a duty because they're now saying, oh, well, we relied on that. We relied on that.
What if they're acting as neither? What if they sort of stepped out of the rigid confines of the role of title insurer, the rigid confines of the role as escrow agent, and they're simply good-hearted people facilitating a transaction? At that point, don't they assume the duty to represent the facts they represent in a non-negligent manner?
In that scenario, I would say that, well, first of all, let's lay aside any licensing or unauthorized practice law issues just for a minute, but just assume that they're acting in that neutral capacity. We're here to facilitate this transaction, and we think it's going to be okay to go forward. Again, we're still talking about duty, is to say, did they have the duty to guarantee that? Are they guaranteeing that? Or are they simply saying, we think this is okay?
No, they're not guarantors. The insurer is the guarantor.
Right.
But once they undertake to start informing, facilitating, and if not counseling, at least supplementing the understanding of the parties.
Sure.
Don't they sort of create their own duty under the restatement to do that non-negligently?
I don't think so, because they're being sued specifically as escrow agents, not following. In other words, the representation. The key is, what was the representation? And as I understand appellant's claim, the way that it's written is the negligent misrepresentation is in the escrow instructions. It is in the.
Well, no, I'm talking about the proposed amendment, which deals with some of the emails, and there I think they're just being sued as human beings, not as escrow agents or title insurers. They're saying these people undertook to tell us stuff. The stuff they told us turned out to be false, and we want to argue about whether they were unreasonable in doing so.
And that there again, I think that's where it comes back to duty. Did they have a duty to get it right? Did they have a reasonable basis upon which to rely on them getting it right, outside the bounds of every other safeguard that's in this process? Escrow instructions, written contract between the parties, contract for title insurance. I mean, the title insurer was originally a part of this lawsuit. Those claims were settled out, and so all we're left with is the issuing agent acting as escrow agent in this case. And I think to suggest that the escrow agent can trigger its own duty by asking questions based on even a mistaken understanding is problematic, because we're going to get past Birkins again if we're going to open Birkins.
By asking questions. I think the assertion is that it can trigger its own duty by making representations, which is a little different.
It is different, and I guess, again, then we're talking about, are these material representations, given the fact that we have escrow instructions that govern what the escrow agent is supposed to do? Are these representations to be treated outside the bounds of the party's existing relationship?
Counsel, we're talking about tort action now, a negligent misrepresentation, not the contractual language or requirements of the contract. I mean, if they undertook or assumed a duty to help them clear title, surely, they could be sued under a Good Samaritan doctrine, right? I mean, that's separate and apart from the escrow instructions themselves.
And that triggers, I think, a better way to say this in response to Judge Swan's question, which is it's not reasonable to say, ignore our contractual relationship that actually is governing what's going on over here. We just want to sue you as human beings and say, hey, we called you up and you told us that everything was going to be fine. That's why the duty vanishes. The duty in this case doesn't arise from any other spot. I can't call, for example, the clerk of court here and say, hey, is everything okay in this appeal? Have I met all my deadlines? And have the clerk say, yes, you're fine. And then argue that the clerk has some sort of independent duty to me to answer truthfully, accurately, go do research and confirm that. I'm not entitled to rely on that. That's not how the process works. The process is, I've got my own duties. They're governed by rules. They're governed by documents. They're governed by, in this case, they're governed by contract. So there's no independent duty that arises, a human being duty, if you will, to say, if I've answered your question, I've done it correctly.
Well, but let's take a slightly closer analogy, because
Okay.
you've got all sorts of government immunity problems
Sure.
with your clerk example.
Oh, sure.
But let's say that I'm just not entirely comfortable with this escrow agent, this title company. They seem a little uncertain of themselves. So I call up another title company with whom I have no contract, and I just ask for advice. And out of the goodness of their hearts, they do some research and they provide it to me. It might seem like a raw deal for the volunteer title company, but if they do undertake to advise me about this, might they not have a duty to do it properly?
I think that I think that's a dangerous road to go down because of what's being sought. What is being sought is dispositive advice about a situation that individual is not responsible for, and to say that everyone gets to reasonably rely anytime they get a statement of opinion from even an expert in the field without some sort of duty attached to it. That's where I'm struggling.
Reasonable reliance is going to be a question of fact in a lot of cases, and
Sure.
it probably becomes easier to establish when in fact, you're dealing with the title company who's handling your transaction.
Correct.
But if you agree that a duty could arise with respect to somebody you don't even have a contract with, why couldn't it arise with respect to somebody you do have a contract with? It may be that over time the economic loss rule limits you to certain remedies, but I don't think it limits your theories of recovery. Right?
I think it does, Judge Swan.
Clearly fraud would be actionable,
Sure.
right, as a tort.
Sure.
There's no question. And negligent misrepresentation is sort of fraud light, isn't it?
It is fraud light, and I think that's the reason why it doesn't exist usually in the panoply of claims brought in these scenarios, is because if the escrow agent has complied with its duty as an escrow agent, that's a greater than responsibility than mere ordinary negligence. So the trial court analyzed the facts and said the escrow agent in here complied with the escrow instructions and therefore lived up to its duty and did not have a duty to go outside the escrow instructions. And so again,
It chose to. That's the problem. It chose to do more than it had to do, and it may that. In some sense, that may seem unfair because here it's just trying to be even more helpful than it really had to be, but it was deeply wrong also.
we don't, when the duties are outlined by contract, it is, I would say, rare for any court, I can't think of an example right off the top of my head, where an accompanying negligence claim clearly for the contents of the contract, you and I contract to build a house, I build the house, I do it wrong, you sue me under breach of contract because that is what governed the scope of the duties. And I feel like that's what we're dealing with here is your job is to close our transaction in accordance with the escrow instructions, and trying to manufacture a claim based on statements given in that process of negligence simply because the parties failed to deposit with the escrow agent an agreement that would actually say, hey, free and clear, free and clear.
We've touched on an interesting unsettled question.
At a certain level.
Yeah, because if you're the general contractor, sure, I have a contract with you, I sue you in contract. I think it's relatively unsettled whether I can sue the plumber because the pipes leak after a couple of years on a theory of negligence.
Right. And that's the difficulty. And in this case, though, I think we're talking not about a separate plumber. We are talking about the escrow agent and its agents and its representatives acting as escrow agent in the process. So I still think it's all within the same house as escrow agent, and that's why it's governed by the contract.
But if we're doing this house analogy and you tell me that the house has certain attributes and I rely on those statements, they turn out to be false. Are you saying that I can't sue you for negligent misrepresentation? You told me the house had air conditioning. It turns out it doesn't. There was nothing in the contract about air conditioning, but you told me it did, and you forgot to put it in. Can't I use negligent misrepresentation then to get my air conditioning?
I think that would be tough without a writing, Judge. That's the difficulty. And again, and let's assume we have a contract that says no previous representations are valid. I mean, that's what we're dealing with here. This is the sum total of all of your instructions right here in this document. But oh, by the way, you told me it would have air conditioning, and even though the contract is silent as to air conditioning, well, when it's got that sort of incorporation clause that says this is everything, this is all we've got to go on, I think we've got a problem to come back and say, oh, negligent misrepresentation. You said something that didn't make it into the final document that should have governed your duties, but since you said it, even though it's not written down, you're still responsible for it. And I think the duties are outlined by the instructions in this case. That's what makes it different.
Certainly have statutes in some contexts that would allow that case, right? Consumer fraud statutes.
Of course.
If you sell me a used car and it says as is, but you've told me that it has a V12 engine in it and it turns out to have no engine, I've still got a consumer fraud action against it.
Correct.
And so are you saying that the common law doesn't extend that far, but legislation does?
I'm saying it doesn't because fraud is treated specially because fraud requires that knowledge or reckless, that reckless aspect that takes it outside of the document. And that's what's left open in Birkins and the other cases like it, is to say, hey, if there's fraud going on here, That's a whole different level, and we're going to impose liability for that. But it's got to be an obvious fraud, not simply a mistake, which is what we have in this case. I have 30 seconds left. We've briefed the attorney's fees issue fairly clearly. If there are any questions on that, I can probably answer one in my remaining time. But just in closing, we obviously believe the attorney's fees question was timely, given the fact of the unsigned minute entry and a non-complete judgment that was originally signed, and then of course our application was submitted shortly thereafter. We would ask the court to affirm as to the summary judgment motion and to reverse as to the timeliness of the attorney's fees application. Thank you.
Thank you, counsel. Rebuttal?
Yes, thank you. A few points, Your Honor. First of all, I think one thing that hasn't gotten enough attention, and it's probably my fault, is the escrow instructions say 0 encumbrances. Trial court never discussed what that meant. We argued it means there aren't going to be any encumbrances, or if it's ambiguous, you got to look to the party's intent. But the trial court never said what that meant. What else can it mean? It means 0 encumbrances. So we submit the escrow instructions do, in fact, say there's not going to be any encumbrances, and therefore there was a breach of contract when it turned out that, in fact, there was. In Berkins, the escrow agent, it was reversed, and the escrow agent could have liability because it guessed wrong as to whether or not the construction loan agreement that the buyer was going to put on the property had to be, the proceeds of that, whether that had to be used for construction. And there was no requirement anywhere that that was the case, but the, I think the Supreme Court said no. You had a duty, escrow agent, to inquire further, essentially, even though it admitted there was nothing in the escrow instructions that said anything about that, and nothing, no other document said that the construction loan that the buyer was going to get had to be used for construction. And they said, gee, no reasonable seller would enter into such a deal if that were the case. And so based on that, they sent it back and reversed the summary judgment. In this case, the escrow agent knew what the deal was, knew it was supposed to be free and clear. That had been the subject of much discussion. So this is a stronger case than Berkins for saying to the escrow agent, you didn't act in accordance with what you knew was the party's agreement. In Berkins, it wasn't clear what it was, but they said you had a duty to do something else, and it kind of defied common sense to do what you did. Thirdly, I want to say that there's been talk about a subjective agreement. We submit it's really not subjective if everybody knows what it is. I mean, it's not written down, but everybody knew what it was. It had been discussed, and there could be no deal if that lien had not been extinguished and if the property was now free and clear. So we submit there is nothing subjective about it. Yes, it's probably unfortunate that the parties didn't have a separate written agreement. They trusted the escrow agent to do that. But in point of fact, the escrow instructions do say 0 encumbrances. Somebody has to explain what that means. The trial court never discussed it, and we say it means what it says, 0 encumbrances. But if it doesn't, and if it's ambiguous, then, because there's no other provision that talks about encumbrances, then in fact, look at the party's intent. And the party's intent, all three parties, it's in the record, affidavits and deposition testimony. So there really wasn't any question about that. It was just it was the other way than what the court ruled. In Centennial Development, that was based on a commitment, a title commitment. Here, that's not the essence of Count 9. Count 9 is they made an affirmative representation. Restatement second of torts 552 is right on point with that. If that's in your business and you make that type of representation, then there can be liability. ARS 2015-62 applies to commitments, title commitments, preliminary title reports, or binders, but it has to be a report. And in this case, the only one that Touchstone had before these representations showed the existence of a lien. So we are not relying on that title commitment, which we're not relying on that, and therefore it's not, the statute is of no assistance to the escrow agent in this case. So we would ask that court reverse the granting of summary judgment, reverse the denial of motion for leave to amend, reverse both motions for summary judgment, and send it back to the trial court for further proceedings. Thank you.
Thank you, counsel. Take this matter under advisement and issue a decision. Court's in recess.
It's good to meet you.
Same here.
Nice job.
We'll talk later.
All right.